Hey guys, welcome to Bubble Man's World. I have a special guest here today with us. I have local Vancouver activist, lawyer Kirk Tousaw. Where are you from originally?
I'm from just outside of Detroit, Michigan.
Detroit, Michigan. I remember when you showed up, it has to be like 10 years now ago.
Yeah, 2002 we came to
So
Vancouver.
12 years ago. So Kirk's been around a long time in the scene. You worked with Mr. Conroy for...
I did.
For a while there?
Mr. Conroy QC.
Mr. Conroy QC, right. There it is.
Great mentor, great lawyer.
And today one of the reasons I invited Kirk over to talk was the Owen Smith extract edibles case that was recently, I don't know if you'd call it convened or...
Judgment rendered by the Court of Appeal.
Judgment rendered by the Court of Appeal. So a lot is people are talking about what it means and what it is and how it affects Canadians, patients, designated growers, non-patients. So I thought I'd invite Kirk over to go over a little bit of how the case started, the first decision in 2012, and then where we're at just recently.
Yeah, and thanks very much to you, Bowman, for having me here. And before I give you that kind of recap, your viewers may be interested to know that you actually were the focal point of two moments in both the trial and the Court of Appeal decision, and I'll tell those stories a little bit later.
Excellent.
But I had the great privilege and really good fortune to be retained by Owen Smith, who was at the time of his arrest a baker of edible products and a maker of other cannabis-based medicines for the Victoria Cannabis Buyers Club of Canada, Victoria-based, operated by Ted Smith, no relation to Owen Smith. And Owen was making cookies in his apartment. The smell leaked into the hallway. Police showed up, and he was arrested ultimately and charged with possession of THC for the purpose of trafficking. And we immediately decided that since he was making these medicines for sick people, for people who use them for medicinal purposes, to better their quality of life, and because the existing scheme in Canada at that time did not allow for patients to use anything other than dried marijuana in the MMAR, we thought, well, we've got to challenge the law because people are being helped by this. This is literally saving some people's lives, improving the quality of life of other people, and there's no reason that Owen Smith should face 5-10 years in prison maximum for engaging in this behavior. So we launched a constitutional challenge. In 2012, we went and did about a 20-day trial. A bunch of members of the club, very, very brave people that I was really honored to meet, came and testified about the impact that medical cannabis and medical cannabis derivative products, either topical products or edible products, or tinctures or concentrated forms of cannabinoids like bubble hash, for example, how these products assisted them in regaining quality of life or treating their serious symptoms and conditions. So they told their stories to the judge, and I had the privilege of helping tell those stories, and it is a privilege. Ted Smith testified about the club and the history and the background of the club, which has been serving and helping people in Victoria and elsewhere for a very, very long time.
It's got to be 15 plus years.
Yeah, I mean, right there from the beginning.
Absolutely.
Of really a medical cannabis now revolution in Canada. And so we were successful. The judge understood that restricting patients to dried marijuana only violated their dignity, violated their autonomy. It infringed on their Section 7 charter rights to liberty and to security of the person in a manner that wasn't consistent with the principles of fundamental justice, because the rules and restrictions were arbitrary. It made no sense to him, and I think to any thinking person, why you can grow and possess the dried product, or as a designated producer you could grow the dried product and provide it to your patient, but then the minute you put it into a tea or made it into an oil or turned it into a cookie and wanted to administer it in a different form than either smoking or vaporizing it, or a hash or a concentrate, you became a criminal. And
I think that you could.
I mean, that's ridiculous and arbitrary, isn't it?
The analogy of the tea, you know, like explaining to the judge that, look, you know, she's using it legally as a dried herb. The minute she puts it in her hot water, steeps it and pulls it out. I mean, because that sounds less like you're making an extract, but the reality is
that's what you're doing. You're extracting the cannabinoids into a weak oral solution, and then you're ingesting it orally. And of course, the medical cannabis forms you filled in for the government had the option of checking oral, which the judge found to be puzzling, and their Health Canada's document, Information for Healthcare Practitioners document, is chock full of information about how to ingest it. Bunch of studies referenced in the footnotes about edibles, topicals, all sorts of science, and it was sort of like, well, you're telling doctors about all this stuff, and you can check off oral, but if the patient actually does that, they're committing a crime for doing that. Right. And so we educated the judge about cannabis and cannabinoids, and here's where Mark actually comes in, because he provided me with some very, very good macro photos of trichomes. And close-ups of trichomes, living from the plant and from dried cannabis. And it was instrumental, really, in educating the judge about what the medicine is and how it's not really in the plant that is contained in these things called trichomes. And I really, when you got a visual like that, right, yeah, it sinks it in.
It's educational for certain.
That's exactly it. And part of what I do in the courtroom is educate, because most people don't have any idea about this stuff. I mean, certainly if they're not either consuming medical cannabis, or even if they are but don't understand really how it's all working other than it works, yeah, you got to educate. Yeah, so we were great. I was great. The decision came down. We were very pleased to win that. The judge struck dried marijuana from the MMAR. The judge modified the definition of marijuana in the MMAR to include all Schedule II substances. So that actually included synthetic THC, for example, but basically cannabis resin, anything you can make with cannabis.
Did he strike the word dried? And
he struck it out.
And then just use the word marijuana?
Just use the word marijuana,
which
that's right.
He also helped define as all of these extracts.
As all of these Schedule II substances.
All right.
And ultimately that remedy gets disagreed with in the Court of Appeal when we get to that point. So the other side appeals, of course, and we go and argue the appeal, and we spent about half of the oral argument time discussing a legal concept called standing, and this becomes relevant because there was a dissenting opinion in the Court of Appeal that dealt with the standing issue. And standing is basically your right to make certain arguments to the court. You have to have, for instance, in a search warrant situation, you have a reasonable expectation of privacy in your home, for example. Mm-hmm. But your buddy sitting on the porch in your home does not have the same reasonable expectation of privacy in your home that you have. Right. And so your buddy doesn't have standing to raise, for example, a challenge to the search warrant in your home. So if they get caught up in a bust and they happen to have some drugs on them or something like that, and they were otherwise arrested and validly searched, even if the search warrant that got the cops in the front door of your house was completely invalid, that person has no standing to raise that because the charter doesn't confer to them a right of privacy in your home.
Because it wasn't their home.
So the argument on standing that the court grappled with was, well, Owen Smith is not a medical patient. He was not a participant in the MMAR scheme. In other words, he wasn't a designated producer producing for a medical patient. He had no license. So how is he in a position to challenge whether or not the MMAR are arbitrary and unconstitutional? And the answer is given by the Supreme Court of Canada quite a while ago. The answer is he's being charged under a criminal statute. His liberty is at risk. And the criminal statute, the Controlled Drugs and Substances Act, under which he will be convicted, you're arguing is unconstitutional because the medical exemption is unconstitutional. And I didn't think, and in fact the Crown agreed, this is well-settled case law, but we spent a bunch of time in the Court of Appeal on that issue. Now, ultimately, we won in the Court of Appeal. That's what happened in 2014, just a couple of weeks ago.
Right.
Incredibly pleased to get a great result. Two of the judges of the three agreed that the charter is breached, that your right to life, liberty, and security of the person is breached by the restriction to dried marijuana only. And they used some very good language in the decision about what Section 7 actually protects. Because it's not just about medical cannabis. What are these rights that we have under the charter? And the right that was interpreted in the BC Court of Appeal was, they said, look, this choice of medicine, the choice of the mode of ingestion of a physician-approved medicine like this, goes fundamentally to what it means to have dignity and independence and autonomy in our society. And I thought that was absolutely spot on and great language, isn't it?
Yeah, really.
Isn't it? I mean, super compelling.
Puts a smile on my face. Really.
Doesn't it? And you read that and you're like, you know what? That's right. That is what it means in a free and democratic society to have liberty and security of your person. If you can't make medical choices for yourself, what do you have?
And it's almost not even a medical choice as much as it's like, okay, you're legally allowed to order pizza, but if you take it out of the box, you have breached a serious law and could potentially serve time in prison.
That's right.
It's like, no, wait a minute. Why would you even do that to your people? That's like an entrapment of sorts.
No, it's a tragedy, and it's an ongoing tragedy, and it obviously should be fixed. The best way to fix it is obviously the outright legalization of marijuana generally.
Right.
But the second best way to fix it is to implement a working medical marijuana system in this country, and I think we've got a long way to go before we have that. So, but this is a step forward. We win. We get a 2-1 decision. The dissent wrote about standing. He felt that Mr. Smith shouldn't be able to challenge these laws because he wasn't a participant in the scheme in any way, didn't try to be. And you sort of say, well, he couldn't have. He could not have applied under the MMAR to bake cookies for the members of the Cannabis Buyers Club of Canada in Victoria.
Right.
He couldn't do that. So what's the point? What's the point of doing that? Is sort of what I said in the Court of Appeal, actually. And luckily, 2 of the judges agreed with us. And also, luckily, Supreme Court of Canada precedent was on our side. And the Crown, quite honorably and correctly, conceded that point at the start of the oral argument. So, really, I think a great decision, a great step forward. I'm very excited to have been a part of it. We may be on the way to the Supreme Court of Canada. There was a dissent. If the Crown wants to go up, I believe they have an automatic right of appeal. They don't even have to ask permission.
That's what a dissent is.
That's what that means. And so
I got one in my case years ago. For my side though, two judges were against me, but one thought, you know what, you should. There was a few reasons why.
This guy's got a point, right?
It's
a case I actually use from time to time in various proceedings. And I'll tell you, here's the other way Mark assisted here with the Court of Appeal decision is you were in the courtroom for oral argument in the Court of Appeal, and I actually stole one of your lines. And I was saying to the judges, it's explaining what a trichome is, of course, because you've got to educate them too. And I said, you've got to think about it this way. The trichomes, the resin glands, that's the message. That's the message. The plant, it's just the messenger.
Nice.
And anybody that watches Bubble Man's World has heard Bubble Man say those words.
Yeah, herb is the messenger.
That's right.
And bubble is the message.
That's right. So
I can definitely accept that one. But if it don't bubble, it ain't worth the trouble. That was the Skunk Man. That was the first one I used, and then I came up with that one. So
I think
that's
I might
great
have a T-shirt or 2 of that on there.
Yeah.
No, it was fun. It was fun to be able to say that, and it's true too. So it was very, very good.
Yeah, well, you definitely have vast knowledge when it comes to cannabinoids, how they're produced, where they're produced. A vast knowledge that a lot of people don't really have. Generally, even in our scene, in the scene that is the cannabis community. And so it's nice to see someone in your position who can stand up and get these laws, not only fight them but potentially change them.
Yeah.
To have a good solid foundation. I mean, I'm constantly disappointed when I see a media story done on cannabis because they don't seem to be inspired to do great work. They don't seem to be inspired to be like, don't you have one guy who will just be really good and learn about? Like, it's not that hard. You can learn about it.
It can be very frustrating to sort of read things that are so inaccurate.
Yeah, there's so much of it.
And that's easy to do, but I appreciate the compliment. It's nice of you, because from somebody with the knowledge base that you have, it's a great compliment. You have the
knowledge. You definitely know what you're talking about, and good. I mean, God thank us, because if someone else was standing up there trying to defend this without that knowledge, in my opinion, that simple knowledge of explaining where the cannabinoids are manufactured inside the glandular trichome head, and that it's such a small percentage of the actual plant matter, there's a huge understanding that would literally change everything that we're even fighting against right now.
No, that's absolutely right, and I mean, one of the joys of being a litigator is that you get to learn a lot about interesting subject matter, and I've been privileged to be able to do a lot of litigation involving medical marijuana and marijuana generally, and I love the plant and have for my entire life, so it's been an absolute privilege to be able to blend those two disciplines together.
Yeah, absolutely.
And try to do good work for people.
Very cool.
Yeah.
Well, I guess my one last question would be, where do we sit with this decision? What does this mean? Does this mean that patients that have MMAR at this point with the injunction going on are able to possess and make their own extracts? Or is that the question of the day?
That's the question of the day, isn't it?
Right.
It's a very interesting scenario because when the trial judge granted us the relief we were seeking, the Crown asked for a year for the government to fix the regulatory scheme. They asked for his ruling, essentially, to be suspended for a year. It's called a suspension of a declaration of invalidity. And that gives the government a chance to respond legislatively. They've done this before. They did it after Parker. They did it a bit after one of the Hitzig decisions. And so they did after Barron. And so not uncommon. And so what the judge did is he said, well, as to patients, no, it's going to go into effect right away. If you are an authorized person, you can make your edibles, you can make your topicals, you can make your concentrates and other derivative products. If you're not a patient, if you're a designated producer, then we're going to give the government a year to legislate. Well, at the end of that year, government hadn't done anything. They came back asking for more time, and the judge, I think quite rightly, said, well, I'm not just going to give you more time to give you more time. I gave you a year to do something, not to do nothing. And he denied that relief. And so at that point, designated producers in BC became able to produce all Schedule II substances for their patients, including bubble hash, including dry sift, including edibles, topicals, you name it, anything. Theoretically, even pure synthetic THC could have been produced by designated producers. Now, this Court of Appeal modified the remedy, said the judge sort of went a little bit too far in granting the relief. Yes, it was unconstitutional to limit patients to dried marijuana only. Yes, it violates their Section 7 rights. But when the judge actually rewrote the MMAR to redefine marijuana as all Schedule II substances, rather than just sort of throwing the ball back into the government's court and saying, here's the problem, fix it,
right,
he went too far. So they modified that remedy. They said to the extent of changing the remedy, we're actually going to grant the Crown relief on this appeal. We're going to declare that those provisions limiting the patients to dry marijuana only are arbitrary, violate Section 7, and we're going to suspend that declaration for a year to give the government a chance to respond legislatively. And so what does that mean for patients? I mean, the government's really been given a year to amend a regulatory scheme that no longer exists in order to allow patients to have access to these products. But what happens in the meantime? Are designated producers now unable to produce for their patients when they were a week and a half ago? Even though we won the Section 7 issue? Are patients no longer able to make their own medicines in British Columbia? Or anywhere in the country? I mean, I think these are some unanswered questions by the way the remedy section of the decision was crafted. And I got to be honest with you, I got to think about it myself before I sort of leap to judgment. I like to talk to some smart people about that, like Mr. Conroy,
right,
and take some guidance on what it really means.
And is it not set up in a way that you can be like, okay, we need to understand, we have a few questions in regards to your ruling. There's no way to get any back and forth with them.
No,
they just
I'm unaware of any.
Laws.
It's not really a dialogue, right? It's a presentation followed by a decision.
Are there firms that you can hire that have brilliant people that just specialize in looking at cases and then telling you what they believe that case?
Well, you could go to a constitutional lawyer. You could get a legal opinion on what the impact is, and you could place some value and some stock in that, and let that guide your actions.
Right.
And we, of course, can go to the Supreme Court of Canada. My client, Owen, has not made any decisions about whether we want to go to the Supreme Court of Canada, because perhaps we don't agree with that remedy.
Right.
Myself, as somebody that's been an observer of how the government's responded in the past to declarations of constitutional invalidity, I don't have a tremendous amount of confidence that this time they're going to do it the right way.
Right.
Because that's not, unfortunately, the track record. And, of course, all of this, there's two other issues that sort of arise. Is how valid is this decision out of British Columbia? It's much more impactful than the trial court decision. Whether or not it's completely binding across the country, I think, is a legal question that would have to be settled, maybe even on a province-by-province basis. And then the other issue is, does it affect the MMPR?
Right.
Are producers under the MMPR going to be allowed to now provide these products to their patients? So far, the answer is no. But perhaps that's part of the government's regulatory response. I don't know the answer to that.
I have a strong feeling that part of their reason to allow it is that they'll want to allow it for LPs.
Could be. I'm not sure why they didn't do that in the first place then.
Yeah.
I mean, it's difficult to sort of understand the government's thinking behind a lot of this stuff.
I mean, I just can't. I don't really see like small amounts of dried flower as medicine.
Well, for some it is. I mean, to be fair, for some people that is their preferred mode of ingestion,
Absolutely.
and their right to choose it is part of their individual dignity, autonomy, and independence.
I would fight for them.
Of course you would, and I know you would.
Absolutely.
I know you just happen to have a different mode of ingestion.
Well, you know what, and not even that, but lately I get a lot of people, since I started this group on Facebook called the Endocannabinoid System, I've had almost daily a person who has been diagnosed with a terminal illness contact me and ask me how they can get what they need and what is it that they need, and I'm like, well, you need to saturate your endocannabinoid system, you need to take like a gram of like concentrated resin gland heads, and there's different ways of, like, it's even when I pull out my creams that are, the CBC cream that's good for muscle pain and stuff, everyone sees it and they're like, oh, I need to get some of that, where can I get some of that?
Yeah.
It's like, well, it would be nice if you could just get it at the pharmacy or at any of these other,
at the supermarket.
At the supermarket, at the dispensary, at the, they're just not available enough in the model that we're currently in.
So. Yeah, that's right. And truth be told, I mean, the medicine is in the cannabinoids, in the resin glands. I mean, that is where it is.
That's it.
The rest of the stuff is extraneous.
Yeah, absolutely.
It may have other impact, flavor, taste. People prefer to ingest it in a certain way, but at the end of the day, we know where the medicine resides, right?
Even in one of Owen Smith's most recent blogs there on Cannabis Digest, I believe it is, he wrote quite a bit about Dave Pate, who was did work for Hortifarm.
And one of our experts in Smith.
And he is an expert.
Oh, I mean, yes.
Really. And if you read Dave Pate's words, it's like all the medicinal value is in the glandular head of the child.
That's right. And actually all of the transcripts from the trial, including Dr. Pate's testimony, are available online. I think it's at cannabisdigest.ca, or if not, you can certainly find a link to it.
It's a great site worth checking
or
out.
Hempology.
Yeah. It's a good site.
Absolutely.
Well, I really appreciate your time, Kirk.
It's been an absolute pleasure. It's been great to come up here to your place and enjoy your hospitality and have the opportunity to talk to the people that love Bubbleman as well.
Excellent.
Great program.
Thanks a lot, man.
Thank you.
Awesome. We'll talk to you guys soon.